Hey, everybody, and welcome to Thursday Night Live here on the Consumer Warrior YouTube channel. My name is John Skiba, and I am a consumer protection attorney and a bankruptcy attorney at the law firm of Jackson White, located in Mesa, Arizona. So, welcome to 2022. We made it. We're here into a new year. I missed a couple live streams there at the end of the year. Please forgive me for that. But so each and every week on Thursday nights, we come on here and we have a discussion on how to deal with debt collection lawsuits, bankruptcy, wage garnishments. We talk about exemptions, homestead issues, all that kind of stuff. Basically, how to deal with it. In the new year, here in this new year, I put out a little video, or I'm sorry, a poll on the channel. And I asked you for some feedback as far as what you want to hear more about in 2022. Overwhelmingly, people wanted to hear about defending lawsuits, which makes sense. That's really kind of the bread and butter of this YouTube channel, is talking about how to defend yourself against junk debt buyers like Cavalry, Unifund, Portfolio, Midland, all those guys, how to defend yourself. So next week, I'm going to put together 5 videos on all 5 days, Monday through Friday. And I'm going to give an update to, 2022 update to defending a debt collection lawsuit, particularly junk debt buyer lawsuits. I'm going to release those on Monday. And so we're going to start right at the beginning and kind of give you some ideas and tactics and approaches you can take that are more updated with some of the newer things that are out there, particularly if you're in Arizona. There's been some pretty big changes in the law that we're going to be going over. So how we do this each and every week is if you have a question, if you're on YouTube, you can put that in the live chat section. I'll put the question up here on the screen and we will talk about it. As I always start with, I have to do my lawyerly disclaimer that even though I'm an attorney practicing in the state of Arizona, I'm not licensed anywhere else. I can't give you any legal advice. This is just us talking on YouTube. If you need specific legal advice, you need to reach out to an attorney in your area and get that. This doesn't create any type of attorney-client relationship. I can't do follow-up questions via email, anything like that. So I wanted to start off with a couple questions that I saw on my on the YouTube channel. I was going through there looking at some of the comments that were put. I'm going to start off with the worst advice of 2022 so far. In response to one of the videos, this guy put, "I just don't negotiate with debt collectors. I ignore the summons they send, and more than likely they just go away. Don't answer the door." Maybe this is tongue-in-cheek. It's always hard to tell. But this is horrible advice. Ignoring them is not going to make the problem go away. What it's going to do is make the problem a lot worse. It's going to you're going to run into a situation where you're going to get judgments against you that could end up liening your home. In Arizona, that's a big change in the law, that your home can be liened by those judgments now. Wage garnishments, all that. It's better to get the information from places like the Consumer Warrior YouTube channel and fight back against these guys. So that's horrible advice there. But I wanted to throw that up there because a lot of people think that that's the best approach to take. Here's one of the other questions. "Hi, John. My question is, who do I settle my debt with? The original creditor, charge off, or the new collection company?" That's a great question, because sometimes I'll talk to people who they'll be contacted by a junk debt buyer or a collection agency, and they say, "Look, I'm not going to go through those companies. I'll just contact the original credit card company or the original medical provider and negotiate with them. That's who I feel comfortable with. That's what I'm going to do it with." I get that. In most cases, they're not going to work with you, particularly if the debt's been sold. If a junk debt buyer is suing you, if Midland, or even if they've just sent you a letter, if you call the original creditor, they're going to just patch you on over to the debt buyer. Same with a collection agency. A collection agency is a company that's just been hired to go out and try to collect on it. They don't actually have any ownership interest in it. If you try to contact the original creditor, in most cases, they're contractually bound to push you back to the debt collector and try to and have them deal with you to negotiate it. So you might as well just start there. That's where you're going to end up anyway. And then I'll do one last question here. This one says, "I'm being sued by Capital One. I already sent the answer, and they sent me back copies of all my statements. The pretrial is tomorrow. How do I broach the subject of settlement or a payment plan?" So what's happened here in this case is they filed the lawsuit. You've responded to it, which is good. You're ahead of the game already. And now in most jurisdictions, they're going to have to provide you some type of disclosure, which is likely what you're having here, which are all the statements and, maybe list of witnesses, that kind of thing. Settlement can happen at any time. settlement discussions, like I've talked about before, they are not discoverable in civil cases. So if you reach out to the attorney for Capital One and say, hey, I want to offer, whatever, $1,000 to get this thing to go away, they cannot use that against you. In most jurisdictions, it's Rule 408 of the Rules of Evidence states that those discussions are not going to be admissible in court. So they can't run in there and be like, hey, judge, they already offered me $1,000. Clearly, they owe the whole thing. They can't do that. And the idea behind the rule is that the court wants to encourage people to discuss settlement. They want them to try to resolve these without having to go to trial. And so because of that, that's why you're seeing that you can talk freely, in essence, about settlement. So that's a good opportunity to do it. The pretrial, if you're in Arizona, this sounds like an Arizona thing. The pretrial conference, if it's in person or even if it's over the phone, a lot of them are being done virtually now. You can discuss settlement there. You can even put together an email and send it over to their attorney or a letter. I mean, we do it all the time. I mean, give them a phone call, talk about settlement. The only thing I tell you, if you come to an agreement, like over the phone, you need to get something in writing, whether it's an email, a letter, something confirming the terms of your agreement, and then you'll be good to go from there. All right, let's go ahead and jump into some of the questions that are out there. We got Alex in Yuma. Thank you, Alex. Each and every week, always here. Let's talk about your question here. Explain the process of appealing a judgment from the Justice of the Peace and Superior Courts. Okay, they are two different approaches or processes, I should say. So in Arizona, the courts are broken up into, we have the Justice Courts. The judge there is the Justice of the Peace. The Justices of the Peace are usually not attorneys, which is surprising to a lot of people. And they deal with cases under $10,000, where the amount in dispute is under 10 grand. Superior Court, the judges are lawyers. They're appointed by the governor, and it's anything over $10,000. If you are going to appeal from a justice court judgment, so that means you've gone to trial or summary judgment's been entered. The tricky thing with this, in the state of Arizona, you have a very short window to file what's called a notice of appeal. You have 14 days to file that from the day the judge signs your final judgment to be able to appeal. Now, the notice of settlement is a very brief document, but you got to file it. And the deadlines are strict. If you're 1 day late, you're done. You missed your opportunity to appeal. Superior Court in the state of Arizona is 30 days from the day the judgment is signed that you have to file with the Court of Appeals. So, and then what happens after that, from Justice Court to Superior Court, 60 days after you file your notice of appeal, you have to provide your opening memorandum. The other party then files theirs 30 days later. Then the court will issue a written ruling. The Court of Appeals is similar. The court will set the deadlines for when you need to provide your briefs to the court. And then they'll also determine if there's oral argument. The thing with an appeal that I tell people you got to think about, an appeal is not, in most cases, a do-over. It's not that you get another bite at the apple. In most cases, what the appellate court is going to be looking at, whether it's Court of Appeals or Superior Court, they're going to be looking to see, did the trial judge abuse his discretion? Is there something where they got it so wrong that the court needs to reverse it? And as you might expect, appellate judges give a lot of deference to the judges who actually heard the case and did the trial. So it's one of these things, you're not going to be able to go in there and present new evidence. Usually there's not even oral argument. Usually it's just submitted in writing. And not only that, in Arizona, unless you post a bond, they can continue to try to do collections while the appeal is pending. I don't see them do that often, but they can do it. So that's something to think about if you're going to appeal it. And they take forever. Even the Justice Court appeals in Arizona could take up to 6 to 10 months. Court of Appeals, you're looking at a minimum a year. So, all right, let me go through some of these things. All right, Joe, let's talk about this. How do you defend an original creditor lawsuit? Now, I have a whole tutorial. I put the link up in the show notes or the comments here. A whole tutorial on handling different original creditor lawsuits. There's some creditors like Capital One, American Express. They don't sell their debt, at least not often. And so they'll often bring their own lawsuits. These original creditor lawsuits, I take a settlement approach to them. Because, and here's why I do that, because you don't have a lot of the defenses that a junk debt buyer does. that hasn't changed hands. They're not going to have trouble with witnesses. They're not going to have trouble with documents. At least you'd hope they wouldn't, because they have all that information there. They're the creditor. They're going to have that information. So unless you have a defense like like some type of identity theft type issue, it's unlikely that you're going to be able to prevail at trial with an original creditor. And then you run the risk that you're going to have attorney's fees added on top of the judgment. So I usually will talk about settlement early on with them. Or you can even enter into what's called a stipulated judgment, where you enter into a negotiated amount that you can pay monthly, even over several years. I'm not going to go into that completely. That's kind of a lot of in-depth stuff, but those are some of the strategies. Non-settlement strategies are the course that we do on pursuing or forcing them to compel private arbitration. The arbitration clause is still legitimate and available to you, just like it is in a debt buyer case, where you could press the issue, try to push it into private arbitration, and then see if you can reach some kind of settlement or dismissal at that point. So the original creditor lawsuits are a little bit more tricky, but maybe check out some of those tutorials I put there in the link, and you'll be able to take care of that. So, all right, this is kind of piggybacks on that. When do you bring up private arbitration in a trial? This is a good question, because it's important to know there in most of those arbitration clauses that are in the terms and conditions of a credit card statement or credit card, terms and conditions, there's a timeline. And usually that says that any party can invoke private arbitration at any time. It'll either say before the judgment is entered, or I've even seen them say before, unless trial has started. So you don't want to wait until trial to invoke the clause there of the private arbitration clause. You want to do that early. And I often, when I do it, will do it instead of filing the answer. They file the lawsuit. You have a period of time to respond. I will file a motion to dismiss and compel private arbitration. If the court were to deny it for some reason, they then give you an opportunity to file the answer. I do it as early as I can on them. So, all right, let's take a look at this one from Darlene. I had a phone consultation with you last month. Thanks for calling, Darlene. I appreciate that. Midland Credit Management is the plaintiff. Midland Funding, the debt buyer. Disclosure documents have been filed by the plaintiff. Should I file disclosure documents? Yes. So the disclosure statement in most states, this is pretty routine as far as you're required to disclose any documents you have, exhibits that you want to use at trial, anything related to the case. Usually you have to disclose if there's any witnesses you're going to call at the trial, what your defenses are. Essentially, the parties have to show their cards. It's not something where you can just show up to trial and say, aha, here it is kind of thing. And that's your benefit and theirs. So the parties have to disclose what they have. I can tell you with most junk debt buyer cases I defend with, the clients don't really have any documents. Monthly statements, things like that. I mean, these cases were charged off often 3, 4, 5 years ago. People just don't keep those things around the house, kind of like that. So many times it's not unusual that documents aren't disclosed, but like if you had correspondence between you and original creditor or monthly statements or something like that, yeah, you would be required to disclose those. Now in Arizona, the initial disclosure statements are not included or not filed with the court. These are just exchanged between the parties. And so that's something to be aware of. I think that's how it is in most jurisdictions. So, all right, let's jump in this one. LP, thank you for the channel. No problem. Can you please speak about what kind of information or documents should be shared between parties during the pre-discovery phase? That kind of, you're asking, it's a very similar question to what Darlene's asking there. Pre-discovery is, formal discovery is where you're requesting documents or requesting information, request for, a request for admission. Pre-discovery is this disclosure period where there are things that you have to voluntarily disclose their existence to the other side. You can't hide it. And so that would be if you had statements. Usually you have to list any witnesses you intend to call, what your defenses are. And the key thing is, if you don't disclose it timely, sometimes you can be barred from introducing it into a trial. And it's possible, in Arizona it is for sure, and in other jurisdictions I know, to supplement your disclosure. So if you do a disclosure statement and then you find some documents down the line that you need to disclose, you can do a supplemental one and provide that. And the same goes for the debt buyer. This is a place where you can kind of hold their feet to the fire as well. because when you get to trial, if they're providing documentation that they haven't disclosed, you can object to it being included in the evidence itself. All right, let's see this. Let's read let's do a bankruptcy question. Can Chapter 7 bankruptcy, can you protect your house? I'm not on the title to the house. This one can be fairly easy. If you don't own the house, I mean, unless a spouse owns it and you have some kind of a community property interest in it, it wouldn't even be disclosed because you don't own the asset. But you can protect the house. If your name is on the deed to the house, you can protect it, assuming a couple things. One is your state has to have a homestead exemption, and all states do, but there's a dollar limit assigned to it. This has been a hot topic here in Arizona lately because the homestead exemption last year, it protected equity in your home of up to $150,000. Now it jumps up to $250,000, which is awesome because the real estate market's out of control right now, and the housing prices are just spiking big time. So if you file a Chapter 7 bankruptcy, let's say, like, for example, here in Arizona, we have to look at how much equity you have in your house. And determining how much equity is real easy. You just take the value of the house, subtract the amount that you owe on it, like with your mortgage, and then the difference between the two, that's how much equity you have. And the equity cannot be more than $250,000. If it is more than $250,000, and again, that's an Arizona exemption. You'll see back east, particularly the exemptions, with the exception of Florida, that doesn't have, it's unlimited. Some, like, I think it was like Tennessee or Kentucky or somewhere, it was super low. It was like $14,000. I don't know how anybody files bankruptcy there, but that's what you need to look at. You take the value of the home minus your mortgage, and then the difference between those two, what that number is. As long as that equity, that amount is not over what your homestead exemption is, you can keep your house. But there's one more important thing. You got to continue to make the monthly payments on it. I've had people bring this up to me where they say, hey, do I have to, in their mind, they're thinking I can file bankruptcy and I get rid of the house, the mortgage, get rid of the car loan, but I can keep the car, keep the house. That's not how it works. Bankruptcy doesn't give you the free car and free house. And they get that. Once you kind of think through it, you're like, everybody would do it if you got free car and free house through it. You still have to continue to pay the house payment, still continue to make the car payment. So, all right, let's see here. Let's see what we have here. Miguel, thank you for sponsoring the channel here and supporting us here. What percentage is a reasonable to settle a judgment that is 2 years old? Mind the judgment that you're judgment proof, no car, no house, and only source of income is VA. Thanks. As far as what's a reasonable percentage, you bring up some good points here, because what's reasonable largely will depend on factors that you have in your life. So the fact that you're saying you're judgment proof, you're saying, hey, I don't have assets, I don't have a car, I don't have a house, they can't lien that, they can't take my car, and your income is likely protected under various exemptions. So they're probably not going to be able to garnish you. So, there's not a whole lot they can do once they have a judgment. I get it, though. Sometimes you still want to settle it because you don't want just the harassment and the unknown and the uncertainty of that judgment. If there's facts like yours, I would start low. I would start probably about 10 to 15% of the total amount if you're able to do it in a lump sum. And I let them know. I let the creditors know if there's a hardship like this. They do take that into consideration, because from their perspective, they're trying to say, how much effort and resources is it going to take us to try to collect on this? And a situation like yours, Miguel, if it doesn't look like they're going to get that much, they're going to take a much lower settlement, because they know if they're trying to garnish your wages or, there's no property to lien, that they're not going to get a whole lot. And so because of that, your situation is probably going to be quite a bit lower than if someone were coming in and they're making, $175,000 a year, and they have a home with a bunch of equity in it, and they have some other non-exempt assets. The settlement there is going to be much higher. You also need to look at it whether it's an original creditor or a debt buyer. Debt buyers will settle for much less. They don't have as much skin in the game. Midland Funding, there's a report saying that on average they pay 4 cents on the dollar for their debt. Some of these other debt buyers, they pay less than a penny on the dollar for the debt. And so they are willing to take much less to get a deal done because they don't have that much in it. Whereas like a Capital One, they're probably going to want at least 50% to be able to get it done at that point. So that's a good question, but it really depends on your circumstances. And if you have hardship, job loss, medical issues, if you're judgment proof, those are good things to bring up in the negotiations, and you'll get a lower a lower settlement to that point. Hey, Nancy, thank you again also for supporting us here. All right. Wow, there's lots of questions tonight. Let's see here. Let's go back to Darlene. Isn't there a big problem when the plaintiff and the debt buyer are not the same, such as Midland Credit Management as the plaintiff and Midland Funding the buyer? Chain of title only shows Capital One and Midland Credit Management. Darlene, you see, you're getting it. You're getting these little details. So Midland Credit Management and Midland Funding's like the parent company to Midland Credit Management. And there's also Encore Capital, who's like they own them all. But those are the little things you need to make because they're separate entities. And you'll see Midland will do things in their documents, like they'll just refer to everybody as Midland. They don't, distinguish whether it's Midland Funding or Midland Credit Management. They'll often say things like, well, Midland Funding doesn't have any employees, so Midland Credit Management services the notes there. It matters. Those are distinct entities, and the chain of title needs to show the transfer. If the plaintiff is Midland Credit Management, then the chain of title and those bills of sale had better be between Midland Credit Management Inc. and the original creditor. Otherwise, there's going to be a problem there. So, all righty, let's see. This is a good question. How do debt collection agencies find your bank accounts? Surprisingly, bank accounts are fairly difficult to locate through legal means. It's not something that, like in your credit report, your banking institutions don't show up. And so a lot of people wonder, how the heck did they find out if they're garnishing, had to garnish my bank account? How do they know where it's at if I don't tell them? What they will often do, particularly credit card companies, banks, and that, they will look to see if you've ever paid with a check or paid with a debit card or something on the credit account that they are collecting on, and they'll start there. And when they get the levy or the writ of garnishment, they're doing it blind. They don't know how much money might be in there, or even if you have an account, but they might just start, fishing. They might just throw the writ of garnishment at that one. I've also seen creditors, particularly on larger accounts, they will subpoena some of your other creditors. Like I've seen recently, I saw a junk debt buyer subpoena a mortgage company and had them disclose any checks that you had paid your mortgage with. And unless you object to that, the mortgage company is going to send them right over. And so that's how they find it. So they'll kind of do these kind of back ways to see how you're paying your other bills, and try to gather all that documentation, and then they can go and hit the bank accounts. Sometimes they will do what's called the judgment debtors exam. And this is essentially a deposition where the court orders you to come in, and they'll require you to turn over banking information, documents, stuff like that. So that's the way that works. All right. John, will your template for a motion to dismiss and compel arbitration work for a debt collector lawsuit in Chicago, Cook County, Illinois? Yes. The template that I have there it's a Word document. You can customize it. I basically just put the important parts in there as far as generally the approach that you're taking, and then the tutorial shows you how to do it, and then you need to go in there and customize it with your specific information. So, all right, we got someone from Manhattan. Good to see you. All right, let's I think I think that'll probably do it for tonight. I've actually got another appointment I've got to run to. Always busy, but hey, I appreciate everybody that's here tonight. We've got a big group, lots of questions. We're here every Thursday night, 5:15 Mountain Standard Time. I will be here. And so if you have questions, you can put them in the YouTube channel. I do pick some of them out each week and we go over them. Or you can come here and post them, and I'll try to get to as many of the questions as I can. If you want to check out some of those tutorials, look at the very top of the live stream on YouTube. You'll see the link there. I'll put it below in the notes, but that has kind of a deeper dive. But check back to the YouTube channel next week. I'm just going to put up over 5 days, 5 different videos discussing the basics in light of 2022, where we're at with everything. and different approaches you can use to work your way through these different junk debt buyer lawsuits. Again, Happy New Year.